Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, can you imagine if you had to go get state's permission before you decided what church you were going to go to this weekend? Or that you needed a license before you spoke freely? Or that you needed government's permission before you would be free from unreasonable searches and seizures? Or that you needed a license before you would not be forced to incriminate yourself? Or that you needed a blessing from the government before you could be free from cruel and unusual punishment? Well, of course not. That's not how the Constitution works. Oh, except unless we're talking about Second Amendment rights. Because if you have the audacity to want to exercise that inalienable right, there are many states that believe that you have to get their permission first before you exercise that right. They essentially want you to go through a background check before you get to go through a background check. Well, two of those pieces of legislation just got knocked on their ass this past week on opposite sides of the country, but for the same reason. And I think that ought to put one state right in the middle of the country on notice. So today, let's spend a few minutes and let's talk about two huge rulings for gun rights and why Illinois' FOID card should be next. Okay, two cases. We've talked about them individually on other videos, this video and this video here. The first is Maryland shall issue Inc. v. Moore. This was a challenge to Maryland's pre-purchasing license requirement, which said you needed to get a license before you could go to the gun store to buy a handgun. The other case we're going to talk about today is the case of Arnold v. Kotek, which was a challenge to Oregon Ballot Measure 114 passed last November, which also would have had a pre-purchasing licensing requirement that would have applied to all firearms. In both cases, we had a judge in Harney County, Oregon, and we had a 3-judge panel in the Fourth Circuit Court of Appeals. In both instances, those pieces of legislation have been thrown out on their ass, and they've been thrown out on their ass for the same reason, which is, well, a right delayed is in fact a right denied. Now, I'm bringing this up because the state of Illinois has 2,415,481 FOID card holders, which is a firearms owner's identification card. It is the state of Illinois' equivalent of what just got struck down in Maryland and what just got struck down in Oregon. This is essentially where you need to go get a hall pass, a permission slip from your state before you can exercise an inalienable right. And when I say that you need to go through a background check to go through a background check, that's not conjecture, because in order to get your license to own a firearm, you go through a very lengthy background check. And then, of course, once you have that, congratulations, you have a card now that says you can go buy a gun. You'll go to a gun store, which of course will run you through the 4473 and all the federal background checks that are mandated there. So yes, you are going through a background check to get a background check. In both instances of the two cases we're talking about, out in Oregon and in Maryland, the court has found, not only is a right delayed a right denied, but there is absolutely no historical precedent anywhere in our country that shows that we can delay the access to what is supposed to be an inalienable right. In Oregon, the Honorable Robert Rascio in Harney County found as follows. First, the Oregon Constitution prevents the legislature from infringing on citizens' rights to bear arms in self-defense, and the 30-day delay in obtaining a firearm through the permitting process does infringe on citizens' ability to protect themselves from an imminent threat. And that is critical there, because all self-defense laws require that you be an imminent threat. If you are an imminent threat, why can you not defend yourself in an imminent nature? And any delay in you lawfully obtaining a firearm actually thwarts that otherwise inalienable right. The judge in Oregon was less than impressed with Oregon's proposed licensing scheme and ruled as follows. The court reiterates its finding that the significant delay imposed by Ballot Measure 114, the enactment of a rational basis policy on a right that requires the deference of intermediate scrutiny, the inability of defendants to institute the policy as written with no FBI background checks, and failing to demonstrate the Ballot Measure 114 permit to purchase policy promotes public safety, all of which unduly frustrate the right to bear arms. Now, for those who advance civilian disarmament, what they will do in defending these laws is say, listen, the Second Amendment only protects the right to keep and bear arms. It has nothing to do with how we acquire or accumulate firearms. And so therefore, anything that regulates how individuals purchase or acquire firearms is not even protected by the Second Amendment. Now, the Fourth Circuit, when hearing that argument from the state of Maryland, kind of laughed it off and brushed it aside as follows. The answer is not complicated. If you do not already own a handgun, then the only way to keep or bear one is to get one, either through sale, rental, or gift. And the challenge law cuts off all three avenues, at least for those who do not comply with its terms. And the Fourth Circuit was also very concerned about why does a state government get to dictate at what time you can arm yourself. The court specifically found, but even though Maryland's law does not prohibit plaintiffs from owning handguns at some time in the future, it still prohibits them from owning handguns now. In order to get a handgun, plaintiffs still have to follow all of the law's steps, and although they will be able to complete each one, it is impossible to do so right away. Plaintiffs can't receive a license to legally acquire a handgun until the state reviews their application, which can take up to 30 days. And we mentioned earlier about how you need to be an imminent threat to use force to defend yourself. Why then are you not allowed to defend yourself through weapons in an imminent nature? The Fourth Circuit was concerned about that as well. Yet under the challenge scheme, an applicant without a firearm cannot possess or carry one until they are approved, a process that can take 30 days. And the law's waiting period could well be the critical time in which the applicant expects to be in danger. So the temporary deprivation that plaintiffs allege is a facially plausible Second Amendment violation. Now, we know if this activity is protected under the Second Amendment, then the government must advance some type of historical analog that shows that we as a society have accepted these types of restrictions. Maryland probably failed as miserably as any state government I have ever seen attempt to do it in any argument in the last few years. The court shot it out of the sky as follows. Indeed, Maryland admitted at oral argument that it had not presented a proper historical analog for the challenged law, noting that it had identified no founding era laws that required advance permission before a citizen could purchase a firearm. So just last week, we saw a case on the East Coast, we saw a case on the left coast, both of which challenged pre-purchasing licensing under the same grounds, both of which were struck down for the same reasons. A right delayed is in fact a right denied. There is no other constitutional right where you must first obtain government's permission before you get to exercise it. Illinois, you have 2,415,481 FOID card holders. The time to strike that law down is right now. Listen, if you have any questions about either of the two rulings we talked about, we'll link them up down below in the description box so you can geek out on it. If you got any other questions about this or anything else related to your Second Amendment rights, you should know how to contact Washington Gun Law by now. If you don't, that's okay. That information is also down there in the description box. Now, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.